morning, and thank you for joining us. We're going to spend some time today talking about how to obtain a green card based on employment. And in particular, we're going to focus on obtaining a green card through what's called the PERM process. A few things before we get started. Scott Legal is a full-service immigration firm that focuses on a number of different types of visas, including green cards through employer sponsorship. We will continue doing our webinar series with at least 2 webinars a month on various different immigration topics. And at the end of this webinar, we'll send out a few things. So one is the PowerPoint that you'll see here today. Another is a comprehensive guide to the PERM process. And finally, a link to where you can sign up for additional webinars. So my name is Kelly LeGrand Weiner, and I'll be the speaker today covering these topics. I have several years of experience processing, cases, in the PERM process, as well as many other different types of employment-based green cards and temporary visas. If you have any questions, please send them through the chat box. We'll try to get to questions, either during the presentation, if there's time, or we'll reserve time for questions at the end as well. Finally, this webinar is being recorded and will be made available on demand. So let's get started. So before we dig into the PERM process, we wanted to just kind of go over very briefly just an outline of some of the other employment-based green card categories. So, you have here the EB1 category. So there's 3 subcategories here. The first, the EB1A, this is for people of extraordinary ability who've achieved sustained national or international acclaim in their field and plan to continue working in that field in the United States. This can be a nice category because it does allow you to self-petition. So you don't need an employer, you can petition for yourself. And so this can be an attractive option. Another is the EB1B for an outstanding researcher or professor. So these are for people that are coming to the US to pursue tenure track positions. The EB1C, multinational manager or executive. So this is very commonly discussed for people who are on the L1 visa. The L1A is a manager or executive, very similar requirements to be an EB1C multinational manager or executive. So very often people will come over on an L1A as a manager or executive and then transition eventually to an EB1C green card. The EB2 category. So for this category as a threshold requirement, you have to have either an advanced degree, meaning a US master's degree or higher, or its equivalent, or exceptional ability in your field. And within this category, there's subcategories. So you can have an EB2 national interest waiver. So this is where you can self-petition and you are asking the government to waive the normal requirement of the PERM labor certification because you're engaging in an endeavor that has substantial merit and national importance. You are well positioned to advance that endeavor. And given that, on balance, it's beneficial to the US to waive this labor test requirement. So this is, a category that can be very helpful for entrepreneurs and others who may not be able to, follow the employer-sponsored green card process. And we do have specific webinars that cover, the EB2 and IW specifically, as well as the EB1A. The other thing that you can do under the EB2 is go through the PERM process. So this is where you would have an employer sponsor you. Again, a threshold requirement would be that the job requires a US master's degree or higher or exceptional ability, and the person, meets that criteria. The EB3 category is for professionals and skilled and unskilled workers, and you can be sponsored for a green card through the EB3 category. Professionals are people who have a university degree, a 4-year university degree or higher, and the job requires a 4-year university degree or higher. Skilled labor would be any work requiring 2 years or more of training or experience or education. And then unskilled workers would be any other work that requires less than 2 years of skills training or experience. EB4 is a category, although it's under the employment-based category. We won't really cover it today. There's many kind of subcategories within it. For example, religious workers can transition to, get a green card through this category. And then there's EB5. So this is based on investment and creation of US jobs. So this is where you would invest either 800,000 or 1,050,000 and show that the business has created at least 10 full-time US jobs. So this is another category, although it's in the EB category, really through investment and creation of employment. All right, let's talk more about the perm process. All right, so for this process, you're going to be looking at the EB2 or EB3 categories. We just kind of described the difference between these earlier. So EB2, higher standard, where you're going to have this master's degree or higher or exceptional ability. EB3 is going to cover any job that requires either a bachelor's degree, 2 years of experience, or less than 2 years of experience. So this process is through company sponsorship. So sometimes, for example, we have, our clients here on E2 investor visas, and then maybe their spouse who has, work authorization to work anywhere. They may be working for a company that's willing to sponsor them, for the green card. So sometimes that's, how people will go through the green card process if their spouse has that work authorization and a company that wants to sponsor them. There are 3 steps to the perm process. So the first and the longest step is the actual perm, the labor market test. And within this process, everything is filed with the Department of Labor. So you haven't gotten to the U.S. Citizenship and Immigration Services yet. You're really still just with the Department of Labor for this part of the perm process. So the first thing to do is draft a job description. You start, of course, with the job description the company would already have for the perm position. However, the perm really is for the company to sponsor a worker for a position in the future. So it's not that the job they're currently doing for the company doesn't have to match what the perm job will be. First of all, it can, but it doesn't have to. And second of all, because this process may take a few years, it's always a good idea to think about what will we want this person to be doing a few years from now? So if the idea is, well, right now they're they're a specialist, but we want to move them to a manager position, then you need to be drafting the job description for that manager position, because that's what you're going to be testing the labor market for. As well, with the job description, most employers are going to be thinking about, what's their ideal candidate going to look like? Strong communicator, lots of kind of extra, more subjective requirements. But for the perm, the requirement for employers is that they can only include the minimum requirements to do the job in a reasonable manner. So that means that the employer has to kind of think about, if I had to hire someone for this job, tomorrow, what are the minimum things they would need to really do this job? So you're not allowed to kind of add a lot of subjective, criteria that would make it, more difficult for U.S. workers to qualify. So once you've drafted the job description, you can file to get a prevailing wage from the Department of Labor. And the prevailing wage is the amount that the employer is going to be required to pay at the time the green card is granted. So it doesn't change anything about the person's current job if they're currently working for the company, but in the future, when the green card is granted, the employer needs to be willing to pay at least the prevailing wage or higher if the actual wage they pay to similarly situated workers is higher. Once you have the prevailing wage, you can start the actual recruitment process. So this is the labor market test. This is where the employer is going to put advertisements, place advertisements in various places. There's, 3 that are required by regulation. So the state workforce agency for the state, where the job will be located, a notice of filing at the actual physical work site. And then also 2 newspaper advertisements on Sunday in the newspaper of general circulation. If it's a professional position or higher, so an EB3 professional or EB2, then you also have to do 3 additional forms of recruitment. So there's a list you can choose from, things like employer website, job search website, local newspaper, things like that. So during the labor market test, the employee applicant is not allowed to be involved at all. It's really an employer-run process where the employer is required to review resumes, determine, does anyone meet these minimum requirements? If they have any, questions, they should, contact the applicant, do these interviews. If at the end of the process, the employer feels that they really did not find any willing, qualified, and available U.S. workers for the job, then they can proceed to the next step, which would be filing the labor certification with the Department of Labor. The perm is an attestation-based system. So that means when you file the labor certification, the employer attests that they did these different, forms of required recruitment. And what can happen is the Department of Labor can always come back and audit the file. So, the employer and their attorney will have prepared together all the proof of the recruitment. So proof of the newspaper postings, the state workforce agency posting, the internal notice of filing, any of the other advertisements, all the resumes, any evaluation of the resumes, notes about the interviews. And so the Department of Labor can ask for all of that, and assess it to see were there really any willing, qualified, and available U.S. workers. So certain things can make it more likely that your case will be audited. For example, if you have a requirement that the person speak a foreign language, and it's not a job like a Spanish teacher or something where it's immediately apparent why a foreign language is needed, that's much more likely to have the case be audited. Any requirements that are outside what's normally required for the occupation. So the Department of Labor has their own internal system for, what they think is a reasonable amount of, of years of experience or education requirements for particular jobs. And if, the job requires more than that, which often it does, the company just needs to be prepared to argue why it's a business necessity, that the applicant have this amount of experience or education. But it is something good to keep in mind, though, when you're designing the job description, just because an audit, if the case is audited, can add several months, to the adjudication time for the case, and it's already quite a long process. So if the case, goes to the Department of Labor, and they can either certify it, audit it, or deny. So if they certify it, that means it's approved, and you can move on to the next step. Right now, the timeline for this first step of the process is quite long, partially because it's taking around 6 to 8 months to get prevailing wage determinations back. And then it's also taking about 12 to 13 months for the Department of Labor to actually adjudicate those labor certifications. So when you have to spend more than a year just waiting for the adjudication, the process does extend, for quite some time. Once you get to the I-140 stage of the process, you've passed like the biggest hurdle. So you would need to file the I-140 while the perm is still valid. They're valid for 6 months. And you file the I-140 with proof that the employer can pay the prevailing wage and was able to from the time the perm was filed. And then also with proof that the employee themselves meets all the criteria in the job description. So if you asked for a bachelor's degree and 3 years of experience, you would need to provide, proof of that degree, and then the employer experience letter is outlining the experience. It's also important to note that generally an employee cannot include experience that they gained with the sponsoring employer. You're only permitted to do that when the perm job is at least, is not substantially comparable to the current job. So there needs to be at least 51%, difference between the jobs to be able to use any of the experience gained with the sponsoring employer. And they do ask questions on the perm to see if any of the experience is gained with the sponsoring employer. And if so, much more likely that the case would be audited or scrutinized. So once you get to the I-140 stage, you can pay for premium processing, which means you can get an answer in 15 business days. Once that is approved, then you can move on to the green card part of the process. So if you're in the United States, and your whole family lives here and you plan to continue living here, generally, you're going to file Form I-485 and do an adjustment of status. It's also possible to do something called consular processing at the consulate, and we'll talk a little bit more about that later. But so for the I-485, you can see here on the PowerPoint, we talked about, is it current or not? So once you get to this stage of the process, the green card stage, the question becomes, is a green card available to you or not? And so right now, the EB2 and EB3 categories are backlogged, which means that for people where their priority date, like if you're getting a priority date that's, today, you're not going to be able to concurrently file your green card application along with your I-140 because there's not a green card available in that category. So it does mean there's a wait right now. Some waits are very long. People born in India and China, there's very, very long waits for the green card. Worldwide, though, there is some backlog as well. So that's, a few months. And you can sponsor your family members as well. So if you have a spouse and any unmarried children under 21, they can also be sponsored for the green card. All right, let's talk about the green card process, adjustment of status versus getting a green card at a consulate. So an adjustment of status, this is where you're going to file Form I-485 with U.S. Citizenship and Immigration Services. Once you've filed this, you can remain in the United States in an authorized period of stay until it's adjudicated. Along with your adjustment of status application, you can file for work and travel authorization. Um, and then oftentimes you're going to have an interview with an officer at the end of the process. For consular processing, this is going to be more appropriate for people who, need to need to travel a lot, or perhaps if you don't live in the United States, if you're completing this process from abroad, if you didn't have underlying status, or if your status ended and you couldn't extend it, then you would go ahead and you would do your green card process at the consulate. This is where you're going to kind of file a DS-260 and all of your supporting documents, so birth certificate, marriage certificate, things like that. The National Visa Center will review the documents and they will send the file to the U.S. consulate. The applicant will attend an interview at the consulate, a medical exam as well. And then after, if the visa is approved, they'll enter the United States with a valid immigrant visa, and then the green card is mailed to them after they enter the U.S. All right, so a very common question, who can pay for green card fees? So fees related to the perm process have to be paid by the sponsoring employer. It's not possible to kind of also have, deals where they say, well, the employer will pay and then the employee will immediately pay them back. Those should not proceed in a situation where you are ever, as the employee, paying for the perm process. That is something that has to be driven by the employer. However, once you get to the I-140, petition and the green card petitions, those can be paid for either by the employer or employee. All right, an important thing to talk about with any green card application is kind of intent. And which visas have dual intent. So the benefit of dual intent in the green card process is that you're allowed to be in the US on a temporary visa and yet also have the intent to remain permanently. So there are many non-immigrant visas that specifically don't allow for this. So as part of the application, they have to prove they have a residence abroad they don't intend to abandon. For example, an F1 student visa, a TN visa. These are visas that have a very high standard for proving non-immigrant intent. You're supposed to have the intent to depart the United States. For visas that do have dual intent, this is obviously makes the green card process a bit easier. The specific dual intent visas are H-1B and L, where there's specific language in the regulations that permits, H-1B and L visa holders to, have some special benefits during the green card process. They can travel freely, whereas most visa categories cannot. We list the O1 here. It's kind of a quasi dual intent visa. There is some very permissive language that says you can, have an O visa and also be pursuing the green card process, but it's not quite as specific as the H-1B or the L, and it doesn't have that special benefit. All right, let's talk about some considerations when moving from a visa to a green card. Timing and underlying visa status. You want to consider how much time is left, on your current underlying visa. Some visas can be very hard to, extend, or it could be subject to a lot more scrutiny if the I-140 has been filed at the time you're trying to renew the visa. So let's say, for example, you have a TN visa. If you're in the perm process, and you're needing to renew your TN, you would want to time it so you're renewing your TN before the I-140 is filed. If you have an I-140 filed or approved, it could be quite difficult to renew the TN because it does have a very high standard for non-immigrant intent. On the I-140, generally, it's a good idea to check that you plan to consular process just to keep your options open. Even if you check you plan to consular process, later on, you could choose to, you could change your mind and choose to adjust status in the United States. But, if you're needing to renew a visa, it does give you a little bit more flexibility to say, well, on this entry, I don't plan to adjust status. I don't plan to stay permanently. I'm planning to leave the country and process my green card abroad. And some officers will be more receptive to that argument to allow you to, extend your visa. So important considerations is figuring out ahead of time, do you want to adjust status? Do you want to go through consular processing? You don't need to have made a firm decision, but you want to kind of have in your mind what exactly it is you plan to do. So you can figure out, just timing, work authorization, issues. Often people are concerned about their children and being in school. So you want to kind of consider all of that, when you're figuring out which is going to work best for you in terms of adjusting status or getting the green card through consular processing. Also consider your family, so your spouse can always kind of adjust with you, but for your children, they can only adjust, as long as they're unmarried and under 21. So if you want your children to be part of your green card application, a good idea to file early to avoid issues with them aging out. All right, so let's talk about some interview considerations. So it's not as common, in the past few years, it hasn't been as common that they call, applicants for interviews, but it is always possible that an employment-based applicant can be called for a green card interview. You would want to review your immigrant visa petition and your green card petition before the interview. So that includes the PERM, the I-140, and the I-485. Or the DS-260 if you're going to the consulate. You want to organize and print all the documents they are asking you to bring. Bring originals that you need, so birth and marriage certificates, things like that. If you're in the United States, you'll have done your medical exam on something called Form I-693. So that's provided in a sealed envelope by the doctor. They do expire after 2 years, so you'd want to make sure it's not expired. And you would also get updated proof of the employment if you're currently working for the person in the United States. So, if you're not currently working for them, you would get an updated employment letter just confirming, that the terms of the job are still exist. If you're in the United States, you need that proof of maintenance of status, so proof that you're eligible to adjust status. And then it's a good idea to meet with your attorney and do a practice interview. Even if you feel like you know the material really well, these can often be nerve-wracking situations. So a good idea to just practice answering some questions, both about the job, your employer, as well as yourself, since they'll likely ask some biographical questions related to your I-485, green card application. All right, so we'll talk about porting a bit and changing employers during the process. So especially because this is a multi-year process, I think it's a very common question, what happens during the process if I want to change employers or I get a new job offer or something like that. So porting allows employees to change employers, but only after the I-485 has been pending for at least 180 days. And this is something to consider just in the sense that, for many people, maybe their employer's going through the PERM process for them. Maybe they're in the labor market test section and they say, okay, great, I want to change to a new employer. Can I bring any of these benefits with me? And unfortunately, at that point, the answer is really no. The fact that you had an employer doing a PERM for you, it wasn't completed, and you left and went to a new employer, nothing really carries over for you. If your old employer had gone through the PERM, filed an I-140 for you, and that was approved, you do get to take the benefit of that older priority date, which can be very helpful in making sure that you could kind of file your green card application much faster. But if, so there's kind of various times where you receive certain benefits, but even if you were keeping your old priority date from this approved I-140, your new employer is still going to have to file a brand new PERM for you. So the only time they don't have to do that is when you get to this point where the I-485 has already been pending for 180 days. At that point, your new employer does not need to complete a PERM or an I-140 for you, although the initial I-140 connected to the I-485 does have to be approved. And then the new employment that you're porting to has to be in the same or a similar occupational classification as the job in your original I-140. So, if your PERM was filled out for you as an accountant, and now you're being offered a new job, as a restaurant manager, that's generally not going to work. You're not going to be able to port, because it's just not similar enough. If you're an accountant and now you're becoming an accounting manager, probably you'll be able to argue that, same or a similar occupational classification argument exists here. So that's something to keep in mind if you do want to take advantage of porting. The new employer would need to file Form I-485J for you, Supplement J. And again, you want to make sure it's just after the I-485 has been pending at least 180 days. You're not eligible to port prior to that. Can I change employers after I get my green card? I think another extremely common question, especially when people are, kind of feel maybe stuck for several years because they feel committed to the employer that's sponsoring their green card. So when you obtain this green card, you are making a good faith attestation that you can plan to continue working for this company full-time in this permanent role. That doesn't mean that you have to work for the company forever, but it does mean that if you get your green card and you quit the next week, there could ultimately be questions at the naturalization stage of the process. So once you get your green card, you can remain on your green card. There's never a requirement that you naturalize and become a U.S. citizen. However, if you did want to become a U.S. citizen, when you do that, they will also look back at the circumstances under which you received your green card. And if they see anything suspicious in the record, it could cause questions for them. So that's to say it's generally a good idea to continue working for the company that would sponsor your perm for at least several months. And if you do leave earlier or, within the year or something like that, there should be some explanation as to why you made that move, just so they don't feel that there was any fraud or misrepresentations, during the green card process. All right, so we've reached the end of the presentation. Let's see, we have one question. Is accounting a good area for EB2, EB3, not at a manager level, about 3 years experience? So I'd say there's no, an accountant can apply for, an accountant who's being sponsored by an employer can apply for an EB2 or an EB3, depending on, what the job requires, if it requires an advanced degree or not, and the person's background. I think that we've certainly done perms where there's less than 3 years of experience requirement or more. So I don't think there's any kind of specific industries that say, yes, this will go through or not. It's a bit more nuanced than that. But certainly, yes, we've done many perms for accountants. It's possible to do. All right, so it looks like we do not have any further questions. So I will close here. I hope everyone has a wonderful day. Thank you.